It's arising out of a 13B petition, my lord. Both the petitioner and respondent at Family Court Davangere, my lord, had filed a 13B petition, my lord, which came to be decreed. The marriage was dissolved.
No. Simple point. When a judgment, a compromise decree is passed, when you are questioning it, you should file an application before the very same court to set aside it. But what you did, you filed a petition under 151. What did the court say? Come up with the application. You don't come up with an application and come before this court. For all this, for unnecessary litigation, I think this writ petition should be dismissed with exemplary cause.
To kindly consider.
You're not understanding by all this argument and by all this thing, you people are doing injustice to the client. Before that, you tell the court, why did you not do it? When it was such a simple one typed application, why did you not do from 2018, and why the case is going around the courts till 2024?
Family Courts Act, my lord, the family court can lay down its own procedure.
So you will do whatever you want to do, and court will lay down its procedure.
The judgment
MFA is not maintainable. Writ petition is not maintainable. Your remedy is to go up before the same court. Now, if this court has no jurisdiction, you file a matter before a court in MFA, and MFA court says that you file a writ petition before this court, and now this court will assume jurisdiction to entertain the petition. Why? I'm not able to understand what is this big difficulty in converting and filing an application. Does it require any kind of effort? For that you have wasted, not means you. Your client has simply from 18 to 24 years before this court.
The petitioner, my lord. Lord, yesterday's matter, my lord, the 13B petition. Yes, ma'am. My lord, I am relying upon one particular judgment, my lord, of this honorable court, my lord. My lord, this is the facts are kind of similar, my lord. At page number 131, my lord, I request my lords to kindly take page number 131, my lord. My request my lords to kindly see the para number 2, my lord. It's arising out of a 13B petition, my lord. Both the petitioner and respondent at Family Court Davangere, my lord, had filed a 13B petition, my lord, which came to be decreed. The marriage was dissolved.
No, simple. The ratio laid down is a consent decree of divorce cannot be challenged by filing a suit. The remedy open to the respondent is to file an application in the same suit in which the compromise is recorded under Order 23, Rule 3A. Therefore, the court below ought to have so and so.
My lord, that is my submission, my lord. Here, my lord, I request my lords to kindly see this particular judgment, my lord. Subsequently, my lord, the respondent filed a suit, separate suit, seeking for a judgment for declaring that particular 13B petition's judgment as null and void. Then, my lord, the petitioner appeared before the court and filed a rejection of plaint application. That particular application came to be dismissed, my lord. While the arguments were commenced, my lord, I request my lords to kindly see in page number 132, my lord, it was submitted that already an application is moved before the Family Court, Davangere, for recalling the said judgment and decree. Even there, a recall application was moved, my lord.
This can't be the ratio.
My lord,
legal position is very clear. You're unnecessarily laboring on something which is unproductive.
My lord,
simple point. When a judgment, a compromise decree is passed, when you are questioning it, you should file an application before the very same court to set aside it. But what you did, you filed a petition under 151.
No, my lord, I filed an application under section 151.
That is not maintainable.
My lord, only the provision I have mentioned as section 151, my lord.
A scope of, it is not about a wrong provision. A scope of it under 151, under an application filed under Order 23, Rule 23, Rule 3 is, it's completely different.
Please, my lord.
What did the court say? Come up with the application. You don't come up with an application and come before this court. For all this, for unnecessary litigation, I think this writ petition should be dismissed with exemplary cause.
My lord, the application, my lord, I request my lords to kindly consider.
You're not understanding by all this argument and by all this thing, you people are doing injustice to the client. Please come to the impugned order. What did the court do? Just court said, come with an application. Why did you not file it? It's a simple question.
My lord, the court below, my lord, asked us to file a miscellaneous petition, my lord. Miscellaneous petition before the same court under Order 23, Rule 3A. But my lord, I request my lords to kindly consider my application, recall application.
First, before that, you tell the court, why did you not do it? When it was such a simple one typed application, why did you not do from 2018, and why the case is going around the courts till 2024?
My lord, I request my lord to
No,
kindly.
only for that you tell the answer. Why did you not file an application? What is the difficulty
I
in
have
filing
filed
the
an
application?
application. Because, my lord, miscellaneous petition would not arise, my lord. I have chosen a course of action challenging that particular judgment and decree itself. I have filed a recall application. The provision I mentioned is section 151. The trial court comes to conclusion that since I have alleged a fraud, the inquiry has to be made. So what, under section 10 of Family Courts Act, my lord, the family court can lay down its own procedure.
So
And
you will do whatever you want to do
No, my
and court will lay down its procedure.
No,
Sorry.
my lord, I request my lords to kindly consider my recall application, my lord.
Why
Request
should
my
it be
lords-
considered?
My lord, I request
A
my
writ
lords to kindly
petition is
see
not
my,
maintainable against that.
my lord, I had filed a MFA, my lord.
If a judge in MFA gives you a permission, it will not get you a right to file a writ petition, which is not maintainable.
My lord, in MFA, my lord, when I had challenged the judgment and
MFA is
decree
not
as well as-
maintainable. Writ petition is not maintainable. Your remedy is to go up before the same court. You go.
My lord, while the final order in MFA was passed, my lord, the honorable court has considered my submission regarding the recall application, my lord, where the court says that I have
Please
already
tell the
adopted
court.
a course of action.
Please tell the court, can a court give you a liberty to file a petition? Now, if this court has no jurisdiction, you file a matter before a court in MFA, and MFA court says that you file a writ petition before this court, and now this court will assume jurisdiction to entertain the petition.
My lord, in the MFA, my lord, in that particular order, MFA order, my lord, the court comes to conclusion that I am also challenging recall application along with the judgment and decree that is passed in the 13B petition. So the court comes to conclusion that appeal is not maintained.
Now you have filed the writ petition.
Please, my lord, because
Now
my lord,
now I will pass an order that you have to go before the same court.
my lord, I may be permitted to convert that recall application to the miscellaneous petition at least, my lord.
You can do it. Why? I'm not able to understand what is this big difficulty in converting and filing an application. Does it require any kind of effort? For that, you have wasted, not you, not means you. Your client has, he simply from 18 to 24 years before this court for no reason. It could have been done by the court long back. Things could have been resolved long back.
My lord, I still feel recall application can be considered because of the judgment, my lord, because only the provision of law I've mentioned.
For
is
that,
section
you will take
150.
6 years.
The different petition is not required as my submission, my
No,
lord.
that's what, for such a thing, you're going around the courts from the last 6 years.
My lord, they had not filed statement of objection. Only in the last week they have filed statement of objection.
Very unfortunate.
I have
state of
moved the
affairs.
matter, my lord. I have moved the matter.
Please go
in
before the
between
court.
also, my lord.
Whatever application that is required, please file it.
My lord, I may be permitted to convert that same recall application as miscellaneous petition, my lord.
Please come. You will file what the court wants you to file. No further direction. The present writ petition is filed, agreed by the order passed in an application filed by the petitioner under section 151 CPC to recall the judgment and decree dated 4/1/2009 on the ground that the fraud has been committed by the on the ground that the fraud has been committed by the other side. The present writ petition is filed. The MC is filed seeking divorce. Thereafter, the parties have filed a petition under section 13B of the Hindu Marriage Act for dissolution of marriage by mutual consent. The said matter was referred to mediation. And in the mediation, they have resolved their differences and settled all the issues, including alimony. Accordingly, memorandum of settlement came to be executed. Both the parties have signed the memorandum of settlement, which was recorded by the court on 4/1/2009. In terms of the settlement, the petition filed under section 13B of the Hindu Marriage Act came to be allowed, and the marriage of the petitioners 1 and 2 has been dissolved. And the marriage of the parties has been dissolved by granting decree of divorce. Accordingly, a decree has been passed. A decree was drawn on 7/1/2019. Now, an application is filed under 151 CRPC, wherein the petitioner wanted to recall the judgment and decree dated 4/1/2009 on the ground of fraud. Then the court has observed that under section 151 CRPC, the said order cannot be recalled. The party is at liberty to initiate separate proceedings if so advised. Then questioning the same, the petitioner had filed MFA number 5637 of 2019, and this court and the division bench of this court by order dated 23rd September 2019 has dismissed the appeal as not maintainable, rejecting the application filed as not maintainable, that he can't file an appeal before the court seeking recall of the original decree of divorce by mutual consent, since the appellant has chosen a particular course of action and it cannot be considered. Now, after that, the present writ petition is filed. Learned counsel for the petitioner submits that the court ought to have considered the application. The family court has its own procedure, and as such, though an application is for only the provision of law is quoted wrong as 151, the court ought to have considered it as an application filed under Order 23, Rule 3A, and ought to have considered the same. This court has perused the material. Learned counsel for the respondent submits that the court had dismissed has held that under 151 such an application is not maintainable. This court, having heard the counsels on either side, peruse the material on record. Unfortunately, in this case, just for a simple application to be filed right from 2019 till 2024, one after the other, the petitions are filed and the matter is kept pending before this court. When the court has categorically stated that when a serious allegations are raised with regard to fraud and other issues, which are serious in nature and which requires a full-fledged trial, and ask the party to come up with an appropriate application. On that ground, now when MFA is filed and a writ petition is filed, this court is not able to understand what is the difficulty of the party to file an appropriate petition before the court. The contention that the family court can draw its own procedure doesn't mean that it should go by to all the procedures known to law. In the considered opinion of the court below had rightly passed the order, and this court finds no reasons to interfere. Accordingly, dismissed.